Criminal Law Book 2. CLJ4. Lecture 009B. Physical Injuries. Welcome back. In this lecture, I am going to discuss administering injurious substances or beverages. This is a type of inflicting serious physical injuries without beating, wounding or assaulting the victim. I will also discuss less serious and slight physical injuries. Read along, stay awake, and learn. Let us start. Administering injurious substances or beverages. Article 264. Administering injurious substances or beverages. The penalties established by the next preceding article shall be applicable in the respective case to any person who, without intent to kill, shall inflict upon another any serious physical injury, by knowingly administering to him any injurious substances or beverages or by taking advantage of his weakness of mind or credulity. Article 263 versus Article 264. Article 263 and 264 use the same penalties, and deals with the same injuries. However, in Article 263, the injuries sustained by the victim must be the result of wounding, beating or assaulting by the offender. Meanwhile, in Article 264, the injuries must be the result of the offender administering injurious substance or beverage, or by taking advantage of the weak mind or credulity of the victim. Elements of Article 264: 1. That the offender inflicted upon another any serious physical injury. 2. That it was done by knowingly administering to him any injurious substances or beverages or by taking advantage of his weakness of mind or credulity. 3. That he had no intent to kill. Element number 1. Under element number 1, the law requires that the resulting injuries inflicted by the offender on the victim must be that of Article 263, that is, serious physical injuries when the offender administered the substance or beverage. If the injury does not fall under Article 263, but the resulting injury falls under Article 265 or 266, it will be prosecuted under less serious or slight physical injuries. Illustration. When one plays a joke on Pedro by giving him a glass of used engine oil to drink, and such injurious substance causes him severe stomach aches which prevented Pedro from working for 2 days, the crime committed is slight physical injuries and not serious physical injuries through administering of injurious substance. Element number 2. Under element number 2, the law requires that the offender must have known that the substance or beverage that he or she is administering to the victim is injurious. Otherwise, the crime will fall under Article 365 under imprudence and negligence, even if the act results in serious physical injuries. Illustration. Using the same scenario, if one did not know that what he gave Pedro was used engine oil instead of Coca-Cola, even if the injurious substance caused Pedro to be permanently incapacitated to work, the crime would still not fall under serious physical injuries through administering of injurious substance. 1, however, can be prosecuted for negligence under Article 365. Element number 3. Under element number 3, the offender must have no intention to kill the victim in knowingly administering the injurious substance or beverage. If the offender wanted to kill the victim but the victim survived, the crime will be attempted or frustrated murder through treachery or poison, and not Article 264. Illustration. Again, using the same scenario. If one wanted to kill Pedro by giving him the used engine oil to drink, but instead of killing Pedro the injurious substance permanently incapacitated him from working, the crime is attempted or frustrated murder by treachery or poison. Administering, defined. The words administering injurious substances or beverages means that the substance or beverage must enter the body of the victim. This could mean drinking or injecting such injurious substance or beverage. If the injurious substance does not enter the body of the victim, Even if it causes serious physical injuries, the crime will not fall under Article 264. Illustration. If one threw muriatic acid onto Pedro's face, which caused Pedro to go completely blind in both eyes, the article violated by one is 263 and not 264. This is because the injurious substance was not administered, meaning it did not enter Pedro's body. But, if one forced Pedro to drink the muriatic acid, and it caused injury which permanently incapacitated Pedro from ever working again, Article 264 is now applicable. Why? Because this time the injurious substance was administered, meaning it entered Pedro's body. Taking advantage of weakness of the mind or credulity. Credulity refers to a tendency to be too ready to believe that something is real or true. It is often associated with gullibility and naivety. It's the readiness or willingness to believe, especially on slight or uncertain evidence. In other words, it's the willingness to believe or trust too readily, especially without proper or adequate evidence. Illustration. One morning, Pedro ate too many hard-boiled eggs and he could not stop farting. Juan, mischievous as he was, handed Pedro a cup of used engine oil and said to Pedro, "Drink this engine oil and it will cure your flatulence." Pedro, being gullible, easily believed Juan and drank from the cup. Why the need to differentiate? If you were assigned as investigator to the case and you wrote the wrong article on the criminal information, the prosecutor will not file the criminal complaint with the court. The reason is, the judge will just dismiss the case on the ground of the act does not constitute the crime charge. Then, you will be ordered to release the suspect until a proper information is filed. In short, it will waste a lot of time and effort on the investigator's part just because of one single number. You might think that this is ridiculous, but there is a very strong reason for this rule. If you recall your human rights education, part of due process is the right to be informed of the nature of the crime filed against the accused. If the judge does not dismiss the case, he or she will be violating the rights of the accused. And, believe it or not, a judge who knowingly violates the rights of an accused is more destructive to the Philippine justice system than the PNP chief being exposed as a member of a crime syndicate. Less serious physical injuries. Article 265. Less serious physical injuries. Any person who shall inflict upon another physical injuries not described on the preceding articles, but which shall incapacitate the offended party for labor for 10 days or more, or shall require medical attendance for the same period, shall be guilty of less physical injuries and shall suffer the penalty of arresto mayor. Whenever less serious physical injuries shall have been inflicted with manifest intent to insult or offend the injured person, or under circumstances adding ignominy to the offense, in addition to the penalty of arresto mayor, a fine of not exceeding 50,000 pesos shall be imposed. Any less serious physical injuries inflicted upon the offender's parents, ascendants, guardians, curators, teachers, or persons of rank, or person in authority, shall be punished by prison correctional in the minimum and medium periods, provided that, in the case of persons in authority, the deed does not constitute the crime of assault upon such persons. Elements of Article 265. 1. That the offender inflicted physical injuries on the victim. 2. That the physical injuries inflicted are not those mentioned in Article 262 or 263. 3. That the physical injuries incapacitated the victim from labor for 10 days or more but not more than 30 days, or shall require medical attendance for the same period. Matters to be noted. 1. In less serious physical injuries, the injury sustained must not be mutilation, Article 262. Nor serious physical injuries, Article 263. Otherwise, Article 265 will not apply. 2. The offended party must have been incapacitated for work for not less than 10 days, nor more than 30 days. If it is less than 10 days, it's slight physical injuries. While, if more than 30 days, it's serious physical injuries. 3. Even if the offended party was able to work, but needs medical attendance for not less than 10 days, but not more than 30 days, it is still less serious physical injuries. The period of incapacity or the medical attendance is the key to telling which article is applicable in a situation. The same is true with slight physical injuries, as you will learn later. For your information, the words incapacity to work in these articles are not limited as to refer only to a vocation. It also includes schooling. Meaning a criminology student who was not able to attend classes for a period of time because of physical injuries shall be considered as incapacitated to work. Qualified less serious physical injuries. 1. Under paragraph 2 of Article 265, should physical injuries be intentionally inflicted in order to humiliate the victim, the offender, aside from imprisonment, shall be made to pay a fine of not more than 50,000 pesos. The fine used to be 500 pesos only, but after RA 10951 was passed in 2017, it has since been increased to 50,000 pesos. Illustration. A college taekwondo coach is enamored with one of his female students. However, the student, who was a minor, was not interested in him, which angered the coach. In order to get revenge, the coach arranged a sparring session between the female student, who was a yellow belter, a beginner, against a black belter in front of the other students. Unknown to the female student, the black belter was instructed by the coach to beat the living daylights out of her to humiliate her in front of the other students. This actually happened. 2. Under paragraph 3, when physical injuries are inflicted against the offender's parents, ascendants, guardians, curator or teachers, or persons of rank or persons in authority, provided the crime is not direct assault, the penalty shall be increased. Instead of imprisonment of arresto mayor, 1 month and 1 day to 6 months, it shall be prison correctional in its minimum and medium periods, 6 months and 1 day to 4 years and 2 months. The reasoning behind the increase in penalty under paragraph 3 is to maintain a certain level of respect for persons who exercise moral ascendancy or authority over others. Article 265 and Article 148. Article 148 defines the crime of direct assault. In order to identify which article applies in cases where the victim of physical injuries is a person in authority, the investigator should look into the reason for the attack. If the reason for the beating, wounding or assaulting is due to the performance of duty or while in the performance of such duty, Article 148, direct assault, will apply. Otherwise, Article 265, less serious physical injuries, will apply. Illustration. One was brought to the police station for attacking the barangay chairman of Gil Sanchez. The attack caused an injury that required medical attendance for 15 days. If one attacked the chairman because the latter was performing his duties, for instance ordering one to go home because it's past curfew, direct assault will apply. However, if one attacked the chairman because he did not like the color of the chairman's shirt, less serious physical injuries will apply. Incapacitated for work, or requires medical attendance. The use of the word or by the law means that each is independent from each other. For instance, even if the victim was not prevented from working, but the injury required medical attendance for more than 10 days, the offender is still liable for less serious physical injuries. The reverse is true and will have the same effect. Slight physical injuries. Article 266. Slight physical injuries and maltreatment. The crime of slight physical injuries shall be punished 1. By arresto menor when the offender has inflicted physical injuries which shall incapacitate the offended party for labor from 1 to 9 days, or shall require medical attendance during the same period. 2. By arresto menor or a fine not exceeding 40,000 pesos and censure when the offender has caused physical injuries which do not prevent the offended party from engaging in his habitual work nor require medical attendance. 3. By arresto menor in its minimum period or a fine of not exceeding 5,000 pesos when the offender shall ill-treat another by deed without causing any injury. 3 types of slight physical injuries. 1. Physical injuries which incapacitate the victim for labor from 1 to 9 days, or require medical attendance for the same period. 2. Physical injuries which do not prevent the victim from habitual work, or need medical attendance. 3. Ill-treatment of the victim by deed without causing any injury. Penalties in paragraphs 2 and 3. Unlike most penalties in the Revised Penal Code which carries a penalty of imprisonment and fine, in Article 266 paragraphs 2 and 3, the penalty is imprisonment or fine. Meaning the offender will either go to prison or pay the fine depending on the discretion or at the option of the courts. RA 10951 and Article 266. Just like in Article 265, the amount of the fines in paragraphs 2 and 3 have been adjusted by RA 10951. Before they were changed, the amount in paragraph 2 is just 200 pesos, while in paragraph 3, the amount is just 50 pesos. To put things into perspective, Act No. 3815, or the Revised Penal Code, was enacted or took effect on December 8, 1930. This means that the code is almost 100 years old, and at that time 50 pesos has the value of more or less 1,000 pesos in today's money. Censure. Public censure under the Philippine Revised Penal Code is a form of penalty that is imposed for certain offenses. It is a form of public reprimand for the offender's actions. However, the specific process of how public censure is imposed is not explicitly detailed in the code itself. The imposition of public censure, like other penalties, would be carried out by the judicial system following a legal process where the accused is found guilty of the crime. The specifics of how public censure is carried out may vary depending on the circumstances of the case and the discretion of the court. Ill-treatment, example. The most common example of maltreatment in paragraph 3 is slapping of the face without causing injuries or dishonor to the victim. If the slapping was intended to cause dishonor or shame to the victim but did not cause an injury, the crime committed is slander by deed, Article 359, under Crimes Against Honor. That is it for physical injuries. Thank you for listening. I hope you learned something. This is Mr. Moslina. Until next time. Good day to you all.